Good day everyone, this is Junaid and I am a regulated Canadian immigration consultant. The topic of this video is really important, and this is about how misrepresentation with the IRC results in the initial stages of your application, when you're becoming a permanent resident or when you're becoming a citizen, and most importantly, how is this going to impact even after you become a citizen of Canada. So importantly is I have made multiple videos about the misrepresentation and withholding facts. This is going to be another one because there are so many cases I've been seeing these days that people are getting banned from Canada instead of getting a refusal on their application. And most of these bans are basically appearing on their visit visa application because they have been found misrepresenting in their application in the forms, in the form of some documentation, police certificates, the FRCs, their marital statuses, or they are misrepresenting their jobs, or they are misrepresenting their bank statements. So these are all the factors can cause a huge damage when you are applying for your application to Canada. So let's start from the very beginning. So if somebody is applying for a visit visa application, this is the initial part. You are not even in Canada yet. You are just applying from outside Canada. So what is going to happen if you are doing a misrepresentation in your application? So there's a straightaway ban. The answer is there's a straightaway ban for 5 years. Okay. So IRCC is not going to just refuse your application, but can be a ban of 5 years. That means you cannot really apply for another application for the next 5 years. After 5 years, the story is going to be different. In some cases, there is a rehabilitation period, which is another 5 years. In some cases, you can still apply for a temporary resident permit, but in that case you have to really justify why you did that, and the chances of getting approval for this application are extremely low. So if you misrepresented in your initial application and you get caught, banned for 5 years. Now next, let's get to the next step. You have misrepresented in your initial application, any sort of misrepresentation. So I was actually observing some cases in the tribunal, the appeal board. They were talking about two kinds of misrepresentation: direct misrepresentation and indirect misrepresentation. I will talk about that in the end of the video. So let's talk the pathway first. So you have misrepresented in your initial application, you get caught, and you are now banned for 5 years, right? And if it didn't get caught and your application went through and you entered Canada. Now, most of the time, people think like if they haven't caught your misrepresentation, if you have misrepresented in any way, you have provided some document which was not legit, you have provided a falsified financial statements, a police certificate, a family registration certificate, or you have not answered truthfully in the forms, or any sort of withholding facts in the forms, some information which IRCC was asking you and you were not providing, or you were actually providing but it is not true. These are all the kinds of misrepresentation. Everything which I have just mentioned, it gets under the misrepresentation or withholding facts. So the consequences, 5-year ban. But let's suppose if your application went through and you entered Canada, let's not say just the visit visa application, let's say in a study permit application, let's say in express entry profile, you have misrepresented and somebody misrepresented and they entered Canada. Now, if somebody entered Canada and they initially misrepresented in their application, there are always chances that IRCC will go back to your information which you were provided initially, the very first application. It happened with a lot of students in Canada that they misrepresented in their study permit application, but they get caught when they finish their education and they apply for their work permit, when they apply for their postgraduate work permit, and now the application reopened in the IRCC, and then they found out that there was some information in their profile now is missing in their previous profile. And if they found out, there are going to be consequences, a deportation and the ban again. So if somebody is misrepresented initially, get into Canada, spend time in Canada, and IRCC found out later on, the consequences are still there. Now let's go a little further. If somebody is on their way to getting a permanent residency and IRCC found out that the person is misrepresenting, there will be, I'm gonna read out from the IRCC. I'm gonna show this picture on my screen as well. So it is from the IRCC website. So misrepresentation bars a person from being granted a citizenship for a period of 5 years. Now, this sentence is very strong. That means if a person has become a permanent resident, whoever gets into Canada, being a student after postgraduate work permit, they apply for the permanent residency and they become a permanent resident, right? Not just a student pathway, express entry pathway. Let's suppose if somebody has become a permanent resident through express entry or any other program. This is not limited to any specific program. This misrepresentation part is not limited to one program or any one specific program. This is overall any program, right? Misrepresentation bars person for being granted a citizenship for a period of 5 years. That means if a person who is a permanent resident of Canada but has misrepresented any time the whole tenure from entering Canada to becoming a permanent resident, can be barred for 5 years to grant a citizenship certificate. That means a person cannot become a citizen for the period of 5 years if you have misrepresented. Now, there are certain categories of misrepresentation. Let's not go there. Video is going to be very long then. So now this part is clear. Person is a permanent resident, now wanted to get a citizenship, but found out that they have misrepresented before. Now there's a 5-year bar to get a citizen. The next information is even more interesting. I'm making this video because some people really think, and I've spoken to some people, and they really think that if you have misrepresented and you enter Canada, everything is good. Canada can't do anything anymore. And some people really think that if you have misrepresented and you are now a permanent resident, that your rights are going to be touching the roof, and the IRCC is just below somewhere and they cannot really do anything. Now listen to this sentence from the IRCC website. I'm going to show on the screen as well. If misrepresentation is found to have occurred after someone become a citizen, so the person, whoever become a permanent resident, fine, but have misrepresented in any of the application throughout the process and now become a citizen, what's going to happen next if IRCC finds out if you have misrepresented? So if misrepresentation is found to have occurred after someone become a citizen, this can result in a revocation of their citizenship, and this individual must wait 10 years before they can granted a citizenship again. This is huge. Like, just think about it. The misrepresentation is never gonna leave you alone. You always have or will have a fear of this particular sentence, which IRCC has mentioned on their website. That means if a person who is misrepresented ever in the IRCC platform and become a citizen, got a passport, now a Canadian citizen, all of the immigration matters have far behind now, and they got the status what everyone dreams to get one, and become a citizen, and IRCC found out that you have misrepresented ever before, your citizenship will be revoked. Your citizenship will be revoked, and you have to wait not 5 years now, 10 years to actually apply for a citizenship again. This is huge. Like, people need to think about it. Especially, I'm talking about those people, and I have seen some videos around in these last few days that when you hire a consultant, when you hire somebody to basically provide all of your information and trust them to do their best to grant you a simple visa application, you need to check your file. before they submit it. First of all, I have made multiple videos about it. You have to check, the first thing you need to do, you have to check if your consultant is licensed to conduct this business. If your consultant is RCIC, which is a regulated Canadian immigration consultant, check the license, check their businesses. Even if somebody is claiming to be an RCIC, you still have to check on the website that if they are entitled to practice or not. Once you do this, you still don't have to just put your hands together and don't do anything further. You still have to check your file before it's submitting. You have to check all of the information is correct. I'm not saying that somebody is deliberately doing something wrong, but sometimes, there are mistakes filling up the forms. End of the day, the licensed consultants are humans as well. They made mistakes too. So you have to check all the spellings are good, all the information provided in the forms are good, and all the documents which are going to be attached in your application are correct. Once you find out everything is good, then you should submit your application. Or sometime, now let's talk about the direct and the indirect misrepresentation. I have seen, I was actually observing one of the hearing in appeal division where the permanent residency was revoked because of the misrepresentation, and the appellant was actually putting everything on the consultant, saying that I have no idea, everything was done by a consultant, so we trusted them blindly, and then we gave all of our information to them, and then we trust the case, and that's their job, and they have done it. So I have no idea why I am getting caught because of the misrepresentation. So this now has become a part of an indirect misrepresentation. So what the honorable judge was talking about, the honorable member was talking about in that specific hearing, he told the appellant that this is your responsibility. The direct misrepresentation is if you are putting your application and you have misrepresented, that means direct. But because the appellant was putting everything on the consultant and trying to make it that I have not done this misrepresentation myself, but someone else has done the misrepresentation on my behalf, so I am clean, and I need to win this case. But this wasn't the case in that hearing. The honorable member told the appellant that this is, even if it's indirect misrepresentation, once you enter Canada and you were talking to CBSA and then they asked you a couple of questions and you never corrected them at the port of entry, and you said yes to all of the questions, and you basically align with your application, you misrepresented at the airport as well. Now this is the direct misrepresentation which you have done at the airport, and even if your consultant did the misrepresentation and you were talking about the indirect misrepresentation, the consequences are going to be the same. Be very careful with your application. I just read the information from the RCC website. It's on my screen as well. You can read it too. And this is your responsibility, being a client, to provide all the truthful information to the IRCC. This will haunt you even after somebody's become a citizen of Canada. That can be revoked, and then you then have to wait another 10 years to get it back, and then again there are going to be chances if you can get it back or not, depending on what you have done and what you have provided which was not supposed to be in your application. So be very careful, and have a licensed person getting in touch, doing your application, so that the chances of all of these matters will eliminate it completely. Thank you very much.